Good morning. I call to order the meeting of the Bills Committee on Inland Revenue Amendments, Tax Concessions for Intellectual Property Income Bill 2024 at this time, and we have a quorum. First of all, we welcome the administration. From the administration, we have Mr. Andy Lam, Deputy Secretary for Commerce and Economic Development. Ms. Benjamin Chan, Deputy Commissioner, Technical, Inland Revenue Department. Mr. Jonathan Look, Senior Government Counsel, Department of Justice. Mr. Thomas Zhang, Deputy Director of Intellectual Property, and their teams.
好，咁我哋
I will first invite the administration to brief us on the contents of the bill. Members who would like to speak, please press the button. Administration, please. Thank you, Chairman. Good morning, members and Chairman. The 2024 Bill on Inland Revenue Amendments, Tax Concessions for Intellectual Property Income seeks to amend the Inland Revenue Ordinance to implement the measures put forward in 2022 and 2023 policy address to promote the development of IP trading in Hong Kong. For many businesses, IP is an important capital asset. It is essential for R&D. Now, by providing tax concessions, we can encourage more corporates to engage in industrial and R&D activities and promote development of the IP industries, and also encourage professional services such as IP legal, valuation, management, consultation, and agency services to further develop vigorously. This will enhance the ecosystem. At present, the capital expenditure on R&D is subject to tax concession, but that is regardless of whether the R&D products can be commercialized. Now, we want to encourage enterprises to pursue legal protection in the form of patents for their inventions and transform their R&D results into actual products so as to generate economic gain. Now, the government proposes to offer the patent box tax incentive for eligible IP. Now, this can enhance developments of R&D and IP trading in Hong Kong so that Hong Kong can fulfill our positions as regional intellectual property trading center and R&D center under the National 14th Five-Year Plan. Many jurisdictions, including our country, have implemented patent box tax incentive. By introducing this tax incentive, we can maintain our competitiveness. As a member of the inclusive framework on BEPS base erosion on profits and the profit shifting under the OECD, we are obliged to apply the nexus approach in determining the extent of IP income that is entitled to preferential tax treatment. The bill covers 5 major areas. First of all, the definition of eligible IP under patent box includes patents, plant variety rights, and copyrighted software. We coin the term eligible IP on these 3 IP assets. They are all generated from R&D activities. And for copyrighted software, registration is not needed under the OGP system. Now, all income generated from eligible IP can enjoy preferential tax treatment. However, the taxpayers must be paying tax for the IP in Hong Kong. Now, the 2023 2024 and 25 budget, the government has proposed to set the preferential tax rates under the patent box package at 5%, much lower than the standard tax concession, much lower than the standard profit tax rate at 16.5%. It makes our incentive very attractive. Now, if the taxpayers develop the patents in-house, then they can enjoy full concession. However, if acquisition of other IP or if part of the R&D is outsourced to a third party, a ratio will be applied. This is in line with the nexus approach requirements under the BEPS package. Now, finally, the government's policy is to promote OGP and plant variety registration in Hong Kong. In order to qualify for the tax concession, IP owners must seek registration in Hong Kong, but that will only come into place 24 months after the passage of the bill. There will be sufficient transitional time for the IP owners to register in Hong Kong to enjoy the tax concession. Now, in last September, we have already consulted the panel on the major measures of the patents box. We have also consulted the trade bodies, including bodies in relation to the accounting sector, the tax institutes, and also local IP industry, and also local universities and R&D bodies. Besides sending the consultation paper to the trade, the CITB, AFCD, and also the IPD have organized 2 consultation sessions to brief the trades on the measures and consulted their views. They generally supported the patents box measure. Now, last year in December, we have briefed the panel in LegCo, and we have the support of members. Now, we thank members for supporting us in the bill, and we urge members to complete the scrutiny work of the bill as soon as possible so that the relevant corporates and bodies can enjoy tax concessions under the patents box regime in the coming financial year so as to bolster our competitiveness as an international financial center. Thank you. I thank the administration for the briefing. Now, we are now going to ask questions on the policy issues. In the first round, I will give each member 4 minutes. So these are the members: Mr. Shanghai Long, Dr. Johnny Ng, Mr. Benson Look, and Professor William Wong. Mr. Shanghai Long, please. 4 minutes. Questions and answers included. Thank you. In promoting Hong Kong to become a regional intellectual property trading center and also the ecosystem, I support the measure. I've talked to the government concerning the details of this exercise. I was hoping that the government could answer my questions back then. Now, we are adopting a liberal approach. Now, the concession would be applied to the accessible profits generated in Hong Kong. Now, I have been involved in the R&D sector as well as its commercialization for many years. Now, there is a lack of such tax concession. A lot of products or a lot of patents have not been commercialized. So I think I agree with the policy goal of encouraging commercialization of research products, but I think the government has come up short in providing tax concessions. It is just barely enough for the R&D sector to stay afloat. So if we can encourage listed intellectual property trading, then the companies can turn a profit and pay tax. So I think we should offer more bonuses to the R&D sectors and the inventors to encourage invention, but the government isn't doing much in this regard. Now, concerning expenditure on R&D, Part A and Part B, there are tax concessions. However, the tax concession is not as lucrative as other jurisdictions. So in the past, through deduction of expenditure costs, how effective was the tax concession? Now, before the government replies, I would like to set some house rule. We are now talking about the bill on patent box tax concession, so let's focus on the matter. Of course, we want to encourage I&T. As the administration said, we are subject to the OECD's requirements of nexus approach. So besides tax concession, can we offer more award to the industries? Is that allowed by the EU? After all, we have to align ourselves with the international standard. Thank you, Chairman, and thank you, Mr. Shang, for your question. I believe Mr. Shang would agree that this term of the government has done quite a lot in terms of promoting I&T developments. Besides patent box tax concession, at various segments, we are offering numerous incentives to encourage R&D teams to engage in invention, including tax concession and subsidies in I&T. We are taking care of the many needs of the I&T sector. Now, the tax concession today is the last stretch of the mile. When the corporations are turning a profit, we hope that through the tax concessions, there will be more incentives for them to engage in IP trading. Now, in designing the tax concessions, we have made reference to a number of jurisdictions. As mentioned in my briefing, what we are seeking to do now is just for aligning ourselves with other tax jurisdictions. We want to adopt the most liberal approach to benefit as many enterprises as possible. If the design is too complicated, the number of beneficiaries may be smaller, and that's not what we want to see. So we want to offer a simple tax concession under the patent box regime, so that regardless of the amount of expenditure and the scale of these businesses, as long as they are generating profits from the eligible IP products, they can enjoy tax concession. So I think paying less tax would add to the sense of gain of these businesses. I hope members will support our measures. Any reply on the second question? Inland Revenue Department. Thank you. Concerning the tax concession measures under the patent box regime, as mentioned by the Deputy Secretary, we need to strictly comply with the requirements imposed by the OECD concerning BEPS. Action 5 of the base erosion and profit shifting package. We don't have much room for maneuvering. If you look at other tax jurisdictions with similar tax concession measures, you can see the designs are very similar. On one hand, we need to comply strictly with the nexus approach. All tax jurisdictions in the framework must comply with the nexus approach. The flexibility only lies in the level of tax rates and also some additional requirements imposed by individual jurisdiction. As we said, we want to make the design of the tax concession simple and competitive. So that's why in setting the tax concession rates, we have made reference to other jurisdictions. Most of the tax jurisdictions set a tax rate at 5% or higher, 10% or higher. So the 5% profits tax rate under the patents box regime is very competitive. Most of the other jurisdictions have a tax rate of at least 5 to 6%.
上議員都
Mr. Shang, a follow-up. Well, I'd like to express my views. The administration said that we have to compare ourselves with OECD or other jurisdictions. It's actually impossible to draw comparisons. 5% or 7.5%, that is not favorable to Hong Kong. So we need to devise a regime that is appropriate for the context of Hong Kong, but I fail to see such details in the papers. Next, Dr. Johnny Ng. Thank you, Chairman. Hong Kong is working hard to move towards an international or regional intellectual property trading center in order to drive the INT development and the upgrading and transformation of the INT in Hong Kong. That is conducive to the new quality productive force in Hong Kong. I support it. In paragraph 25, in relation to publicity, the administration said that we will leverage the ETO and its network to further promote the patent box tax incentive. I'd like to know any concrete measures, tactics to promote to overseas jurisdictions in order to attract enterprises to come to Hong Kong. We need to attract overseas IP to come to Hong Kong to register as OGP. I'd like to know the number of patent examiners in Hong Kong and the relevant services in Hong Kong. Do we have sufficient talents to work in this profession to cater for the demand upon the passage of the bill? Are there any importation schemes in this regard? Administration. Thank you, Chairman. On publicity efforts, there are ETOs and mainland offices. In the dedicated offices, they are in touch with different investors or companies. They are interested in Hong Kong. They want to make investments in Hong Kong. Whenever we have new investment strategies or policies, we'll inform the ETOs or mainland offices so they can promote these initiatives to the companies they have communication with. In the budget, we have already related this message to our ETO colleagues. So upon the passage of the bill, we will also step up publicity in this regard so that our ETO colleagues will be in a better position to promote Hong Kong. That's a selling point. In relation to OGP, we have already recruited 29 patent examiners. They are already working on the examination of OGP. We'd like to develop the team to have a total of 45 persons in the future. In 2030, we aim to have around 100 patent examiners to examine IP so that we can implement substantive examination. Apart from internal training in the IPD, we will send patent examiners for exchanges with the counterparts in the mainland. so that our patent examiners will also receive training in order to bring their knowledge up to speed. We don't have any patent agent right now. In the policy address in 2023, one of the policies is that within this year, we will start our discussion with the industry in relation to the regulatory regime on patent agents. Apart from the eligibility or requirements, training requirements are only on the table. We will also discuss that. For example, what kind of on-the-job training can we provide to examiners? Within this month, the IPD will start engagement with the industry. Discussions will follow. We hope to explore this with the industry. Through the regulatory regime on patent agents, we'd like to enhance training for patent agents. Thank you. Just now, Dr. Johnny Ng asked about publicity efforts. The administration said that the IPD would also be involved. Well, how will the Invest Hong Kong step up publicity? As I said, upon the passage of the bill, we'll be on par with similar countries. We are not in a better position than those countries. Dr. Johnny Ng, any follow-up? Thank you, Chairman. I agree with you. I look forward to more resources being deployed by the administration. Of course, resources should be deployed in a targeted manner to hold events with certain groups. Thank you, Dr. Johnny Ng. The administration, please note Dr. Johnny Ng's views. Next, Mr. Benson Lok. Thank you, Chairman. The 14th Five-Year Plan supports Hong Kong to develop into an international I&T center. It also supports us to become a regional intellectual property trading center. So, in our scrutiny of the tax concessions for Intellectual Property Income Bill 2024, we are actually realizing what our country is expecting of us. Profits tax from 16.5% to 8.25%. I support this policy. I'd like to seek clarifications from the administration. There are IP tax concessions in other countries as well. For example, in China, 15%, our competitor Singapore, 5%, Korea, 4.5%. If we want to become a regional IP trading center, we need to compete with other countries. It's like a race. There's only one champion. So if we are on the same par with our competitors, we may not be able to outperform our competitors. So I'd like to know the logic behind having the patent box tax rate set at 5%. Around the world, we are one of the cities with lowest tax rate. We have full tax. In terms of red wine, we have advantage in terms of tax. We have full tax exemption. All patents need to go through the IPD. I'd like to know on average, the time taken to examine the IP. Of course, we are expecting an increase in the number of IP examinations. There will be increase in manpower, as the administration said. On the protection of IP, arbitration is an important tool in protecting our status as a regional IP trading center. The industry let me know that in the court there are some IP cases they had to go through different judges before proceedings could commence. So the industry is actually worried whether there is sufficient manpower in the legal sector. Do we have sufficient legal practitioners in this regard? These are my questions. Deputy Secretary. Thank you, Chairman. Thank you, Mr. Lo. The tax rate of 5%, of course, in the formulation of this tax rate, it's broadly similar to our competitors, be it Korea or Singapore. Mr. Look also mentioned these tax rates. Ours is better than that in Singapore. One needs to meet requirements in relation to investment or recruitment in order to enjoy an even better rate. However, our rate at 5% does not carry any extra requirements in relation to manpower or recruitment requirements. So our regime is more competitive than that in Singapore. Do we need to further drive down the rate to, say, 3%? Well, we don't find it necessary. To attract overseas enterprises to come to Hong Kong to invest, I believe the ecosystem matters. Do we have an INT ecosystem? Do we have talents? Do we have measures to support the development of INT? I believe this is what we have as competitive edge. For startups, from 2014 there were 1,000 startups. The number increased to some 4,000 startups in 2022. This reflected the robust development of startups and INT. On examination time, there will be more and more patent examiners. We hope they can cater for the demand for the increase in the number of applications for OGP. We are confident that we can handle the examinations. Right now, examinations take 2 to 3 years. The time is broadly similar to other jurisdictions around the world. Of course, different cases have different examination time, having regard to different circumstances, but we are not particularly slower than other jurisdictions. More importantly, one needs to submit an OGP application in applying for patent box incentive. So the approval time, be it long or short, does not affect the eligibility for patent box incentive. I'd like to clarify this point. It's important. On arbitration, I believe the DOJ will have different schemes to support the industry in relation to talents. Of course, in the legal sector, there are different legal areas. IP is one of the specialisms in the INT sector, in the legal sector. Quite many lawyers specialize in IP. Just now, Mr. Benson Look mentioned a situation. Some individual cases were probably transferred to different judges before proceedings could commence. I'm not sure about the reasons behind it, but I believe the DOJ will enhance its work. As a legal dispute resolution center, I think Hong Kong will also double up its efforts. Thank you.
Any replies from the IRD? May I elaborate on the comparison between our tax rates and other jurisdictions' tax rates, especially those in the region, which offer tax concessions on IP income? Now, Singapore, the often mentioned country, how do we compare to it? On tax rates, as mentioned by Mr. Look, and also in the paper, say in Korea, the tax rates can be as low as 4.5%. However, the profits tax for enterprises is progressive. So only the initial amount would enjoy a 4.5% tax rate. Further, income would come with higher tax rates. That's the enterprise income tax. So the effective tax rate should be as high as 6%. For Singapore, there is a 5% tax rate, and there is also another 10% tax rate. As mentioned by the Deputy Secretary, they do impose additional requirements for an enterprise to enjoy the lower tax rate. To be qualified for the 5% tax rate, the enterprise must invest at least 10.5 million Singaporean dollars and also hire more than 20 people locally. For the 10% tax rate, you need to invest 6.5 million Singaporean dollars and hire 15 employees locally. We don't have these requirements. So in this aspect alone, we are more attractive. Yes, we need to follow the OECD's rule, but there is some flexibility for individual jurisdiction. For example, the scope of coverage of IP products in our regime is wider. Besides patents, we also include plant variety rights under our regime. Singapore doesn't have it. Now, concerning income from IP, eligible IP, in many jurisdictions, the definition is the fee for using the IP and so on. However, in our regime, we cover the sale of IP products. The parts of profits attributable to the IP held by the company would also be eligible for tax concession. That is quite unique. And also in many other jurisdictions, there is a the corporate needs to undergo an assessment. However, we don't have these requirements. As long as you are eligible, you don't have to undergo an assessment in order to qualify for our tax concession. So you can apply for a ruling by the IRD and the IPD. The applicant can apply for a ruling, but that is not necessary, and we don't have an advanced assessment rule. So let me follow up on the reply given by the administration. According to the IRD, applicants can secure an advanced ruling. So after the passage of the bill, how much more manpower does the IRD need to vet and assess the applications? And concerning advanced ruling, the taxpayer can voluntarily apply for advanced ruling with us. Now, we have many applications for advanced ruling under the relevant measures of the Inland Revenue Ordinance in the past. So we don't expect we need a lot more manpower to handle the additional workload. If there are lots of applications, then we may apply for more funding on hiring more manpower. But so far, we don't expect such need. And subject to the passage of the bill, when the taxpayer applies for the tax concession, we hope that it would be a very convenient experience for them. That's why we are only requiring the basic information when the taxpayer is filing the tax return. For example, what is the IP asset and what is the nexus ratio and so on. As long as there are such basic information for us to assess the profits, that would suffice. After the assessments, we would select cases for review to ensure that the taxpayers are complying with the requirements under the law. This is the usual practice for other regular tax concessions we are offering, so we don't expect a dramatic increase in workload. Professor William Wong. Thank you, Chairman. I think we can break our discussion into three parts. First of all, the policy objective is clear, promoting I&T developments. We all support that. The second area is the methods we are adopting to achieve the goal. Now, Mr. Shang Hailong mentioned about award, but I think on this occasion we should focus on tax concessions alone. So maybe we can have another discussion about award on another occasion. The third area is about implementation, publicity and training for the necessary talents. I agree with the directions as well. I have two questions. When the patents box tax concession is implemented, who will be the beneficiaries? Now, in research, we have a physical science and also life science. These are the two main arenas. The IP products and the patents generated from these two fields are very different. So you said you would engage talents for assessing the IP products and the patents, but I have to stress that you're talking about two groups of talents here. For physical science, there would be an actual product, and the deduction would be based on the sales of the product. For life science, however, we can sell the product at every stage of the life cycle. For example, if I have discovered something about the DNA, we can sell the products already. And when the research is turned into pharmaceutical products, I can sell them as well. Now, for AI and AI Plus, you said software doesn't cover the patent. Copyrighted software is another category, but data is also a copyright. Is also a copyright. So would you consider including data as well? Concerning the beneficiaries and the talents, in particular, IP or patent agents, I agree we have to nurture this kind of talent ourselves. According to the policy address, the government will promote the development of University of Applied Science. So should we start the discussion now and see whether we can offer training for patent agents at our universities of applied science? Deputy Secretary, I will first speak on talent nurturing concerning patents, examination, whether that includes AI, I will invite Mr. Joseph Yang or Mr. Thomas Zhang for a reply. Concerning patent agents, as mentioned in the policy address, we are going to start a dialogue with the trade concerning the regulatory regime for patent agents, concerning the qualification requirements and the training requirements. Depending on the results of the discussion with the trade, we will decide on the qualification required for a candidate who undergoes patent agent training, and then we will talk to the universities of applied science. The University Grants Committee, or UGC, would meet with the universities funded by it regularly. So when we met with the UAS, we have already given a heads up to the UAS. The Director of Intellectual Property has talked to the 8 universities himself concerning the government's policy on training patent agents. But we need to wait for a consensus to be reached concerning the regulatory regime on patent agents. Then the universities will have a better idea on how to design their programs. I believe we already have the necessary elements in our university programs. It's just about adjusting the programs to meet the market's need. So that's on training. Concerning AI and also patent examiners, may I invite Mr. Thomas Zhang to answer. Thank you. There are all sorts of inventions. So we have 3 major categories on patents, including chemistry, electronic engineering, and mechanical engineering. So of course, there are more breakdowns underneath each category. We will make sure that we have the necessary talents to examine these products. So after the OGP regime was introduced in 2019, for patents examiner, we have been recruiting patent examiners since 2019. At present, we have around 30 patent examiners. The target is to have 100 patent examiners so that we can conduct examinations on patents on our own. That is how we are going to expand our examination capacity. Second, on training, since we have established the OGP, we have maintained a very close working relationship with the National IP Examination Bureau. It is a major patent examination body. It has approved the highest number of patents in the world. So we can learn a lot from the National Bureau. Internally, we are offering training to our patent examiners. We are offering a 3 to 4 month training program to our patent examiners so that we have the capacity to conduct examination on our own. On whether data or AI software can enjoy protection under the patent regime. Usually for software, it would be protected under copyrights. Copyrights doesn't require registration. That is in line with the international practice. Now, if technical issues are overcome during the development of software, then subject to an examination, it is possible that software would also be granted patents as long as it fulfills the 3 requirements in terms of innovativeness, creativity, and also industrial application. So the IPD, the Intellectual Property Department, would vet the claims on its individual merits. The patent examiner would look at each individual software and decide whether a patent can be granted. Now, the tax concessions under the patent box regime cover patents, plant variety rights, and also copyrighted software. It very much depends on the individual preference of the taxpayer whether they would apply for tax concessions for their software under this regime. Thank you.
好追問。
Professor William Wong, do you have follow-up? Yes, I do. Just now we talked a lot about talents in relation to examination. What about the business model? I mean, we have a patent box, be it for physical science or life science. There are different uses. The beneficiaries need to know about this. Actually, the requirements for these two categories are different. Let me go back to my previous question. I mentioned software copyright. In the AI era, data do have copyright. I think the administration should consider this. Thank you. I think the administration should consider Professor William Wong's view and suggestions. Next, Dr. Junius Ho. Thank you, Chairman. I'm not well up in this area, but I'd like to ask a couple of questions. In paragraph 15 of the papers, we need to encourage more R&D, transformation, and commercialization. So how can we transform and commercialize these R&D results? As far as I understand, to develop IP, I engage people to work on drawing and make an application. It seems the development cost, when the R&D results are transformed and commercialized, when I charge others for loyalty, when I have income, the costs will be deducted and offset. And the gross profits are not charged at the current taxable rate of 16.5%. It will be taxed at the concessionary rate of 5%. For example, for services, you'd like to attract others with a concessionary tax rate. However, what about resale? Will it be also considered as a way of commercialization of R&D results? That is patent box as mentioned in paragraph 14. What about I resale my products? I spend $10 million and I sold it for $100 million. So I have a gross profit of $90 million. It's a one-off. So do you mean I only need to pay 5% of $90 million as the tax? Is that the case? Well, before the administration replies, I'd also like to speak. Then the administration can elaborate on tax loss, so that the industry will be in a better position to know about the arrangements in relation to tax loss. Thank you, Chairman. There are many different ways of commercialization of the R&D results. Resale one-off is also one of the ways. However, if you authorize somebody else to use it, it's also another way. If one develops a new product based on the patent, it's also a way of commercialization of the R&D results. If the innovation is new, we'd like to maximize the economic benefits. so that the patent can also bring economic benefits or profits. So whether you authorize somebody else to use a patent or whether somebody else is going to develop their own products based on the patent, there are also ways to commercialize the R&D results. Indeed, if you receive income or profits, yes, it can be considered eligible R&D expenditure, but it also depends on the development behind it. Is the development undertaken by taxpayers or whether there is any outsourcing? In the case of outsourcing, are the parties related parties? Thank you. I'd like to follow up. Using the example you cited just now, it is you who decide on how to deduct. If A develops a product and sells it to B, B sells to C at the price of $100 million. There is no development cost. When he or she acquires it, the cost is $100 million. But then, when B sells a product to C at $200 million, is it the case I have earned a gross profit of $100 million and I will have to pay the tax rate at 5%? Is that correct? Well, that's quite a technical question. Probably Benjamin can supplement. I'll speak on the general principle. In the acquisition of IP, that's not eligible expenditure. When one acquires the IP, one does not develop it. That's the acquisition cost. It's not eligible expenditure. So how can one enjoy the patent box incentive? One needs to, first of all, buy the IP with further R&D. Then one can apply for patent box incentives on a pro rata basis. If there is no development or R&D element involved at all, one is not eligible for R&D expenditure. I mean, it's not considered eligible R&D expenditure, so one is not eligible for patent box regime. Benjamin, we need to take a look at the circumstances. It's not always the case that you have to pay tax in the case of intellectual property. One company may not want to sell IP. Probably the company wants to use the IP. So when one sells the IP to other persons or to other company after a period of time, that may constitute capital asset, and that's not taxable. If a company would like to develop IP and would like to sell it to other companies, perhaps that will constitute income. So there is the possibility of taxation. As the Deputy Secretary said, if in Hong Kong a company works on R&D and an IP is generated, when you sell the IP, when you fulfill all the requirements within the regime, you are entitled to the concessionary tax rate of 5%. In paragraph 12 of the papers, in B, it sets out very clearly the income arising from the sale of an eligible IP. One may be eligible for the concessionary tax rate of 5%, but the prerequisite is that the company must develop the IP on their own. If a company resells the IP, unless there is further R&D involved to add value to the IP, then the company may, on a pro rata basis, enjoy the 5% concessionary tax rate. However, If you resell the IP without any development or R&D, in principle, the company would not be eligible for the patent box incentive. What about the patent box or tax loss? The concessionary tax rate is 5%. Comparing with other preferential tax regimes, if there is tax loss, how to treat the tax losses? There are special arrangements. As you can imagine, if a taxpayer has more than one source of income, for example, there are general sales income taxable at 16.5%. There are also other streams of income taxable at 5%. Say a profit of $10,000. There's a loss incurred at $18,000. Can the loss of $18,000 be directly set off against the income that is taxed at the ordinary rate? As you can imagine, for the $18,000, if it's profit, then you can enjoy a lower tax rate. So the loss should not be allowed to directly set off against income that is taxed at the ordinary rate. So under the existing Inland Revenue Ordinance, where income at concessionary tax rate is concerned, downward adjustments are involved. Only after downward adjustments are made can the loss be allowed to be directly set off. To be set off. If 18,000 loss at ordinary tax rate, whereas $10,000 at concessionary tax rate, we'll need to use an adjustment factor. So we'll take the lower figure. For the $10,000 at the ordinary rate to be used. In our clause-by-clause scrutiny, we'll further elaborate on this. We plan to use this system in our tax concessionary regime. Next, Mr. Ambrose Lam. Thank you, Chairman. I support the tax incentive. Actually, it supports the commercialization of the R&D results. It's also in line with our country's policy goal to develop Hong Kong to be an international INT center and a regional IP trading center. We're talking about innovations, patents, and so on. However, when it comes to trademark, probably some members of the public are not aware of the fact that they actually have the IP already. So, in principle, they should enjoy the concession. They may not be aware that such is actually IP as well. So they don't know it is actually covered.
Administration, please. Thank you, Chairman, and thank you, Mr. Ambrose Lam. Now, it may seem that much of the tax concession is focused on patent. The reason is that, as we have mentioned, we need to follow the OECD's requirement on adopting the nexus approach. So under this nexus approach, the definition is patents or intellectual property that's functionally equivalent to patents. So it includes a trademark and designs and so on. For copyrights, no registration is needed. And also we have plant variety rights. So from the 5 categories of intellectual properties, we have singled out patents, plant variety rights, and copyrighted software as eligible IP. So they are patents and other IP assets that are functionally equivalent to patents. We are only including these 3 IP assets under the patent box. For the other categories of IP assets, they are not functionally equivalent to patents. That's why they are excluded from the concessionary regime. Next, Mr. Duncan Chiu. Thank you, Chairman. I fully support this tax incentive measures to encourage more inventors to stay in Hong Kong and generate profits in Hong Kong. I think the directions have been clearly explained by the administration. If a patent is registered or generated from outside Hong Kong, well, the 5% concessionary rate only applies to patents generated in Hong Kong. For patents registered overseas, the taxpayer may have to pay tax in accordance with the foreign jurisdiction tax rate. So we have something called transfer pricing. Some Hong Kong enterprises are suffering from unreasonably high licensing fees. So that's a form of transfer pricing because our tax regime is more attractive. Of course, that may be beneficial to our economy. However, from the perspective of competition and also the nexus approach, are these situations covered? Let's say if I license my patents to someone in Hong Kong and then through a subsidiary or a partner, a very inexorbitant licensing fee is charged. So that's how they are transferring the profits from overseas to Hong Kong and gets our preferential tax rate. This has also come across my mind when I was studying the bill. So may I invite Benjamin on how Section 20 of the Inland Revenue Ordinance can deal with these situations. Concerning the income from the eligible IP, maybe we are talking about royalties for patents. So let's say a Hong Kong enterprise receives licensing fees from a corporation outside. So whether we would see a situation when a very high licensing fee is charged to a Hong Kong enterprise. Now we have some rules on transfer pricing. Same for other tax jurisdictions. For the scenario you mentioned, the key is whether the other tax jurisdiction has similar requirements. Now, if licensing fee is paid to a party in Hong Kong, then the taxpayer in the overseas jurisdiction may have to pay may enjoy tax concessions over there. So we may adopt the transfer pricing principle and allow only parts of and only allow a partial concession. On the other hand, if tax is already paid in the other jurisdiction, then we may adjust the tax rate imposed on the taxpayer. There are cases, maybe this is not a royalty. The IP asset is sold as a product. Is sold as a product. So the profits generated from the sale of the product includes patents, includes income generated by the patent. So will the taxpayer exaggerate the amount attributable to the patent? Now, in assessing the portion of IP in the product, one has to adopt the transfer pricing rules adopted by the OECD rather than doing it arbitrarily. So there are requirements under the law. We have already thought about possible loopholes. Thank you. If I may, I would like to follow up on Mr. Duncan Chill's question. Now, we don't have the law on transfer pricing yet. So do we have cases where taxpayers in Hong Kong transfer their profits to other jurisdictions to enjoy a more competitive tax rate and hence cause a loss to our revenue? Now, we already have transfer pricing requirements in the ordinance. Now, if we turn the situation around, let's say a Hong Kong enterprise is paying a huge sum of licensing fee to an overseas body, then if it doesn't comply with the individual transaction principle, then we can adjust the concessionary rate downwards. So we will not suffer a loss in terms of government's income. No follow-up questions. The second round, Mr. Benson Look. Thank you, Chairman. Now we are striving to enhance our economy, and we are poised to become a regional intellectual property trading hub. So I think the patents box is a very useful tool. Now, we understand that we need to make an investment in order to earn a profit. That's the 101 for doing business. So what is the long-term fiscal position for this incentive? Will we suffer a mild reduction in revenue in the coming years, but in a certain number of years' time, we are going to turn around? Now, the target for the Intellectual Property Department is to have 100 patent examiners by 2030. At present, the time required for vetting a patent is 2 to 3 years still. With more patent examiners, can we shorten the assessment period? Or is the ball not in the courts of the IRD? Administration. Thank you, Chairman, and thank you, Mr. Look, for your questions. On tax revenue, it is impossible to come up with an accurate estimation because we haven't conducted a separate survey on IP products. We don't have a separate item under the tax return for collection of data in this regard. Now we have 70,000 effective or valid patents in Hong Kong. As I said in the opening, IP products eligible for tax concession do not necessarily have to be registered in Hong Kong. There is just a requirement for these IP products to be registered under the OGP within 2 years. So concerning the beneficiary enterprises and also the revenue foregone, it is very difficult to estimate them, the number. Concerning the time required for assessments, when there are lots of accumulated cases, more patent examiners can help. But sometimes a lot of to and fro and back and forth is needed. More information may be required from the taxpayer. Questions will have to be asked. On the other hand, the applicants need time to explain why their product is innovative and meets the 3 requirements under the rules. So the long assessment time may be due to the huge caseload, and it also depends on how ready the applicants are in defending their products. So our plan is to gradually increase the number of patent examiners. Then at least on our part, we have the sufficient manpower to deal with the anticipated extra workload. No follow-up questions from Mr. Look. Professor Wong, second round. Now I mentioned foreground IP and background IP. Now in the second round, there is the products and there are foreground IP, and then for acquired IP, that is background IP. So for background products or background IP, this is also eligible for tax concession, no? Mr. Lam? For IP acquired and then with further R&D conducted on the products, then for that part, of course, that is eligible for tax concession. However, for non-eligible IP income or expenditure, that won't count. What I mean, we would like to see the inventor to continue to enjoy the income from their invention. So let's say if I sold my products to a foreground researcher and then they sell the background products, will I still be benefited? So that's just a curious question. Benjamin. First of all, background IP, that is the IP invented by the original creator. The creator comes up with an IP product, then they license or sell the products to another person, and then they further conduct R&D on the products and enhance the IP, and then use it to create another product to make a profit. Is that the scenario you are referring to? Yes, as the creator, I have the royalty. I would get a bit from the subsequent sales of the products. So I receive an income still. So will I still be eligible for the tax concession because we want to encourage creators to create? Any IP which meets the requirements under the regime, they will be covered. An IP is a patent. With the R&D done in Hong Kong, the creator is just receiving royalties from the middleman. So the creator is still an eligible taxpayer under the patent box. So I hope you can enhance publicity on this matter, because we want to encourage creation by stressing that the invention will generate profits for you for a lifetime. Now, and also, pricing is crucial because the market is the one which sets the price. So if the transfer pricing mechanism is not based on the market's pricing, then it would undermine the attractiveness. So you shouldn't be the one, the government shouldn't be the one to set the price. it would be a deviation from the principles of market economy, and it would discourage creators to create in Hong Kong. So of course you are worried about markup prices. So the point is you should have the talents to spot these overmarking.
回應。
Administration, any response? Well, it concerns tax assessment done by the IRD and whether there are sufficient IP professionals for evaluation in the market. I'd like to ask Benjamin to respond to the first part. Well, I'd like to speak on evaluation first. I don't want the government to be cheated by others, so we set a standard price, but that's not how the market operates. The market price doesn't fluctuate. It varies, but that's not in line with the OECD practice. As an inventor, I'd say, well, I'll move to another jurisdiction. They offer a much higher price. So in this case, we fail to retain the inventor in Hong Kong. Administration, I'd like to speak on transfer pricing rules. The rules actually regulate transactions with two related parties. They do not regulate unrelated parties' transactions. Actually, for unrelated parties' transaction, the arm's length principle is used. If there is no relationship at all, they are willing buyer and willing seller, and they decide on a price based on the market price. So this problem wouldn't occur. In terms of taxation, what we are worried about the most is unrelated parties transaction. Anything that leads to taxation benefits is not allowed. So this is what we mean. We don't mean any price in relation to IP will apply the transfer pricing rule. Where the transfer pricing rule is applied, when an enterprise invents an IP, and when the IP is used to manufacture some products, when the products are marketed, when the company would like to claim that some certain part of the profit from the product is from the IP, then we request using the transfer pricing rule of the OECD. We need to see the profit split. The OECD's rule is that there are many methods to determine this. This is adopted in many places. Only under these circumstances will we request the taxpayer to use this rule in relation to transactions among unrelated parties, such as IP transactions. They are not subject to the transfer pricing rule. Professor William Wong, any follow-up? However, when I sell the IP to you, you carry the risk. That they have agreed on the price beforehand. So it's a catch-22 for you. You need to think how to solve it, but you also need to have a commercial sense. So you need to tread cautiously. Of course, in tax assessments, we tread very cautiously to guard against any malpractice leading to taxation issues. However, In the case of unrelated parties, as you can imagine, what incentive do I have? For example, if I were a seller and I sold an IP to you, how would I know that you would benefit from it? If the seller sells a lower price, sells a product to a buyer at a lower price, the cost is actually lower. In the future, when it is deducted, then the price will also be lower. In this case, not necessarily one will reap benefits in terms of tax. However, in case of related parties, it is very convenient to use these arrangements. In the case of substantial loss or profits, one will obtain tax concessions. But we do agree, in case of any suspicious cases, we will make sure that the taxation process is free of any errors. Mr. Ambrose Lam. Thank you, Chairman. When the government rolls out tax concession measures, we will estimate the possible decreased income that the government will receive. But this initiative is aimed at increasing the tax that the government will receive. So what is your estimate? That is the possible increase in the tax the government will receive within 1 year. We are now on the same par with other competitors, so how can we attract other people to come to Hong Kong? Thank you, Chairman. As we have already explained, we would like to estimate the number of beneficiaries while we were studying the measures. There is no independent file and return requirement, so we only have a figure. There's no breakdown, so it's actually difficult for us to estimate the amount of tax revenue that we will receive less. Eligible taxpayers may not necessarily register their patent in Hong Kong. The IPD has a total of 70,000 patents in Hong Kong. There are also US, European, Chinese companies that have IP. They don't register in Hong Kong, but they also have profit from the IP, so they will also benefit from these tax concession measures. The range is actually too wide for us to draw any conclusion. In this year of assessment, when the IRD has started collecting data, we'll be in a better position to tell you whether there will be more and more companies benefiting from this initiative. So the ecosystem will become more robust. We will be in a better position to give you more details in due course. On tax revenue, there's no such an item, so we simply can calculate the amount. The company needs to include the amount under this. Right, the administration said that there is no breakdown. Mr. Duncan Chill. Thank you, Chairman. Professor William Wong mentioned something quite interesting. I'd like to write on it. For example, Company A manufactures a pharmaceutical product that's about cardiovascular relaxation. Then, Company B improves the drug and changes its use. If the contract is very clearly set out that all the rights are given to Company B from Company A, then all the tax concessions should be enjoyed by Company B. However, I said that the drug was actually for cardiovascular relaxation use. That may involve a legal point. But I'd like to talk about another situation. How much does Company B need to do in order to justify the fact that it actually enjoys the tax concessions? If Company B does not do a lot of R&D and simply uses the drug for another purpose, there is no background R&D conducted. But Company B reaps a lot of benefits in this regard. Does Company B still enjoy the tax concessions? In other words, how much does Company B need to do in order to enjoy tax concessions? Benjamin, in our bill, there is a clear formula. That is, how much income from IP is entitled to tax concessions. We need to work out a ratio. It's not like we have income of $100. Supposing we meet all the requirements, it does not necessarily mean that the entire amount of $100 can enjoy the tax concessions. We need to see the ratio. That's an R&D fraction. The denominator is the R&D expenditure. The denominator is the gross expenditure, including the acquisition of IP. The price will also be covered in the denominator. So the acquisition cost is actually included in the denominator. So when you undertake further R&D, the denominator will cover that. But of course, the denominator will also cover R&D. So it would never be the case that you can have 100% of the tax concessions. In our tax concession measure, we encourage R&D. So if you simply buy or acquire an IP, if it just so happens that you buy a lucrative IP without any R&D undertaken, you can put it this way: you won't be able to enjoy a lot of tax concessions, or it may be the case that you won't enjoy any tax concessions at all. I'd like to confirm Section 17 F12. Maybe we can clarify that in clause-by-clause scrutiny. Any further question? If no, we'll start clause-by-clause scrutiny. I suggest we can use the Chinese version for the scrutiny of the bill. The legal advisor will, at the same time, study the English version of the bill. Members can refer to the marked up copy. CB brackets 1 534/2024 brackets 01. For the convenience of other participants of the meeting, member can read out the number on the top of the page of the marked up copy. Administration, please.
Thank you, Chairman. Members, I will take members through the clause-by-clause process of the bill. Now, the long title of the bill. It is not shown on the markup copy. Please refer to the blue bill. Now, it says the bill is to amend the Inland Revenue Ordinance to give profits tax concessions for certain accessible profits from an eligible intellectual property income. Second, to provide for the treatment of losses in relation to accessible profits chargeable to the profits tax at more than one concessionary tax rate. And 3, to provide for related matters. Clause 1 of the bill is the short title, Inland Revenue Amendments Tax Concessions for Intellectual Property Income Ordinance 2024. Clause 2, the Inland Revenue Ordinance will be amended as set out in sections 3 to 14 of the bill. Now we are now at clause 3, that is pages 1 to 2 in the marked up copy. It is to amend section 14 of the Inland Revenue Ordinance, 14(5). After the amendment, if a person elected to apply to apply the tax exemption on the eligible parts of the profits tax, and then there are also concessionary, and there are also trading receipts charged at an ordinary tax rate, then that would be dealt with under Schedule 8. So that's the same treatment for other tax concessionary measures. Now, Clause 4, pages 3 to 5 of the markup copy, it amends Section 19C, brackets 1, 2, and 4, and 5 of the IRO. And there is also the addition of Section 19C, brackets F. 19F sets out the offsetting arrangements between losses and also profits from the eligible income. Now, we will go into the details later on. Clauses 4, brackets 2 and 3, page 6 of the markup copy, amending Section 19C, bracket 6 of the IRO. It sets out that if the taxpayers are eligible for concession, then the taxpayers will be paying the profits tax in accordance with the concessionary rate. Now, if the percentage is at 0%, that is no tax, then the loss incurred or sustained from those activities cannot be used for set off against the profits. Now, the principle is simple. If the profits incurred is not liable to tax, then similarly, the loss incurred cannot be used for setting off against the profit. Now, that's in accordance with the practice we are using under the tax concession regime for eligible income generated by family offices. We're now at Clause 5, that is pages 7 to 13 of the markup copy, amending Section 19CA and CB of the IRO, so that concerning the profits or losses generated from trading receipts, and also the concerning profits or losses subject to the prevailing profits tax concessionary tax rate at 8.25%, we set out for the offsetting arrangement. Now, the amendments will be so that the offsetting arrangement will be applicable to the arrangements in Schedule 17 CD. Now, the concessionary tax rate is 8.25% and 6% and 16%. So as I mentioned, if there are two items of profits or losses subject to different tax rates, then we need to apply a fraction before setting off the losses or profits. Now, let's say if the trading receipts is $10,000 and at 8.25% tax rate, the loss was $18,000. Under this scenario, if the $18,000 are to be used for setting off the $10,000 of trading receipts, then first of all, we need to apply a fraction to the 18,000 losses. The adjustment factor would be a ratio between the two tax rates. So as I said, one tax rate is 8.25%, the other is 16.5%. So the $18,000 loss would be divided by 2, and we arrive at $9,000. So the loss incurred by the activities subject to the concessionary tax rate is $18,000. When it is used for setting off the trading receipts of $10,000 subject to the normal tax rate, only $9,000 can be used for offsetting. So this is applicable to Section 19 CA and CB. They will be applicable to the tax concessionary measures under the patents box. Now we are now at Clause 6, pages 14 to 27 of the markup copy. Now this is to add Section 19 CC, CD, CE, CF, and CG in the ordinance. Now concerning the profits and loss from trading receipts, and for loss and profits of trading receipts at two different concessionary tax rates, and we are setting out the requirements. Now, the previous session refers to when there is only one concessionary tax rate and one trading receipt. But there are scenarios where there are trading receipts chargeable to profits tax at two different concessionary tax rates. So Clause 6 provides for these scenarios. So the arrangement will be like this. It is comparable to that in 19 CA and CB. In other words, if profits and losses subjects are chargeable to profits tax at two different concessionary tax rates, then an adjustment factor should be applied. Now, we have three sets of tax rates at the prevailing level. We have the 8.25% concessionary tax rate and 16.5% ordinary profits tax, and also the new 5% profits tax for patent box. So how can gains, profits, or losses chargeable to different tax rates offset each other? So we are setting out the orders of set off here. To protect the interests of taxpayers and to avoid confusion, we propose that the concessionary trading receipts charged at a rate higher than the rate of the other trading receipts would be set off first. Now, as I said, there are 16.5% and 8.25% tax rates in profits tax, and also there is a 5% tax loss. In that case, the loss would first be used to set off the profits generated from the activities subject to the 16.5% tax rate. If there is still losses left, then it would be used to offset the 8.25% profit. So as long as there is no longer any loss and all loss is set off, then that would be the final outcome. Clause 7 of the bill, page 28 of the markup copy. This is to add the new section 6G. It includes section 40AY and section 40AZ. So section 40AY sets out the concessionary tax treatment and access requirements for ascertaining concessionary portion. The details are set out in Schedule 17FD. The measures will apply in respect of a year of assessment beginning on or after the 1st of April 2023. Now, as I mentioned, we need to strictly comply with the BEPS Package Action 5 imposed by the OECD. In recent years, the OECD often updated their requirements in concerning new tax regimes in many jurisdictions. So under Section 40AC, we give power to the Secretary for Financial Services and the Treasury to, by way of negative vetting, amend Schedule 17FD. Actually, this power is also conferred to the Secretary for Financial Services and the Treasury concerning the schedule in relation to other tax concessionary measures. For example, tax concessionary measures for eligible income from the investment holding vehicles of family offices. Now here I would invite the legal advisors to talk about 40AZ, Section 20AZ. Now, earlier on, we have sent a letter to the government concerning our questions. That is CB brackets 1534 brackets 04. Now, I draw your attention to paragraphs 1 and 2 of the letter. The reply from the government is CD brackets 1 53404. Now, the answers are set out in paragraphs 2 and 3. Now, according to the Interpretation and General Clauses Ordinance, the Secretary can, by way of notice in Gazette, amend Schedule 17FD concerning the proposed concessionary tax rate. Now, to avoid confusion, we think the focus is not on amending Schedule 17FD, but rather we can use the negative vetting procedure to amend the proposed new schedule. Now, according to the law, according to the bill, the effect would be immediate after the Gazetted process. Now, we think it may have a wide impact on the taxpayers. Now, we have made reference to various legislations like Section 8 of the Motor Vehicles First Registration Tax Ordinance, which provides that the motor vehicles first registration tax rate may be varied under the positive vetting procedure. So we invited members to consider whether a reply should be sought from the administration, whether we should adopt this arrangement.
究竟
Administration, can you let us know why we're not going to go for negative vetting? Instead, we are authorizing the Secretary for Financial Services and the Treasury to do so. In our document, we also explain the reasons from the administration. Just now, Mr. Benjamin Chan also explained a bit. It's not something new in our bill. In section 15L3 and in 48W1, they also cover the tax rates. I'd like to point out quite a substantial difference. Just now, the legal advisor mentioned the arrangements in relation to motor vehicles first registration tax ordinance. When members of the public make a decision, they are subject to the change in the first registration tax upon the announcement of new measures. After a company files a tax return, what is the rate of the tax concession rate? It's not about a different tax rate when you make the decision one day earlier or one day later. In the document, we also mentioned in many pieces of subsidiary legislation, much consultation is involved unless there is urgency. Otherwise, this is the usual practice. In subsidiary legislation, using the method of negative vetting, the subsidiary legislation needs to wait until the period of 28 plus 21 days. This is a common practice. Apart from consulting members in the negative vetting period, there is also sufficient time in the Legislative Council brief or when the subcommittee is formed under the House Committee, the administration is willing to further elaborate on any reasons for amendments. Is this tax rate subject to change? It's not like that. This is a general empowering provision. That is, the Secretary can amend the provision 17FD. It gives the administration flexibility. Within a short period of time, the Secretary can amend legislation. So in the future, when we implement the legislative amendments, when we need to introduce new requirements as a result of any change in OECD requirements, we can take forward that very quickly. I hope members will understand that this is an effective and ongoing mechanism. Mr. Wen Kong. Thank you, Chairman. Just now you mentioned 8.25%. That is another type of concessionary tax rate. So what about this one? How does it compare to this one? Mr. Wen Kong mentioned the concessionary tax rate of 8.25%. That is the two-tier mechanism as the administration introduced. Well, I'd like to know for 5%, it's under Section 40AZ. What about 8.25%? It's under which ordinance? Under which section? The IRD? Thank you, Chairman. For 8.25%, many tax concessionary measures also use the tax rate of 8.25%. In different tax concessionary measure provisions, they are different. It may be written as half of the ordinary tax rate. It's not written as 8.25%. So more often than not, the tax rate under Schedule 8 will be used. I mean half on the ordinary tax rate under Schedule 8. That's quite common. For EIHVS under family offices, the tax rate will be written in the provisions. Another provision is also introduced to authorize the Secretary for Financial Services and the Treasury to amend the tax rate under by virtue of subsidiary legislation. Often, it's the contents of the schedule that are changed, or extra or additional provisions are introduced under that ordinance. It also provides for which provisions can be amended by the Secretary. Not all provisions used the same way. Mr. Dorian Kong, any follow-up? Yes, I do. I'd like to share with the administration my view. Schedule 17FD is the soul of the ordinance. Much of the operation can be found under Section 17FD. As the administration explained, it depends on different types of tax. It's possible to use negative vetting, as other modes of operation or provisions are involved. I'm a little bit worried. For Schedule 17FD, that's the most important, so I'll read it first. I understand the question from the Legal Services Division, and I understand it has quite a huge impact. Deputy Secretary, well, usually we put in place the arrangements in either regulation of the subsidiary legislation or in the principal legislation in the format of a schedule. But many ordinances have schedules as well. The schedules are comparable, if not even more complicated than the schedule we have right now, that is Schedule 17FD. They need to be written in a very detailed manner so that the frontline officers will know how to deal with different situations. In a council, we sufficiently discuss the principal legislation as well as the framework. When it comes to implementation, that is requirements in light of OECD's requirements, when we need to effect some changes, these are technical amendments. They can be introduced by way of subsidiary legislation or schedules. This is a common practice. So the common practice is that we can take a little bit more steps. We need to go through the panel meeting, the panel in Legislative Council, where we discuss the topic. We consult members. Afterwards, we'll work on the subsidiary legislation, after which we further discuss finer points. If all members have different questions, it's likely that subcommittees will be formed. Subsidiary legislation is technical. We may not need to go through each and every subsidiary legislation or ordinance under the subsidiary legislation. in order to allow us to respond to members in a timely manner. This practice is common and is effective. Mr. Kong, it's actually only on the 13th of May, that is yesterday, that I received a reply from the administration. Maybe I can go back and study the letter. It's 12:40 right now. Our meeting is scheduled to complete at 12:45. We used a little bit more time. If members and the administration do not disagree, I will extend the meeting by 30 minutes until 1:15. I'll ask the legal advisor to follow up on another point. If we need to use negative vetting, once the notice is published, it becomes part of the legislation immediately. If we only set up a subcommittee after the concessionary tax rate is in place, assuming there are amendments, there may be widespread impacts. Well, Chairman, maybe I'll respond to it briefly. Well, the biggest difference is that when a company pays a tax, the concessionary tax rate can be enjoyed by the company is regulated. That can be enjoyed by the company is regulated. Unless there is urgency, the concessionary tax rate will be enforced only after the 49-day period is over. It's rare that the concessionary tax rate is enforced immediately. In the assessment by the IRD, the IRD receives the tax return once every year. So there is no time sensitivity right here. We don't use a new concessionary tax rates to conduct tax evaluation or assessment. Yes, I do understand. The legal advisor or the administration has already explained that may affect the purchasing decision of members of the public when it comes to buying properties or buying cars. What is the impact? Some enterprises may come to a place because of the concessionary tax rate. Will it give others the impression that after 49-day period, the tax rate is once again amended? It's like deceiving these persons to come to Hong Kong to conduct business. The impression may be even more serious than the impact per se. So maybe the administration needs to tell us the administration needs to give us a list to tell us which ordinances have authorized the Secretary for Financial Services and the Treasury some powers. The tax concession measures are actually the same as the arrangements put in place by the foreign source income exemption under Section 17 FC. Many of the contents are similar, especially when it comes to the nexus approach. In Schedule 17FC, the bill also empowers the Secretary for Financial Services and the Treasury to amend Schedule 17FC. The explanation was the same, as the nexus approach was the requirement on the OECD. So when the OECD makes amendments and when it requires Hong Kong to amend our local legislation, oftentimes we are pressed for time. So in order to meet the requirement of the OECD, there is indeed a need for us to amend the schedule quickly. That said, we understand the concerns of members as well as the legal advisor. We can study this point when we go back. Thank you.
咁跟住我哋而家繼續就
We will now resume clause by clause scrutiny, that is clause 8, in the amend section 51C of the IRO. Now it concerns the requirements on keeping of records concerning the operation of the taxpayers. Now pages 68 and 69 of the markup copy in the schedule, there are additional requirements on record keeping, so that's why we need to amend section 51C to emphasize the change. Clause 9, pages 32 to 34 of the markup copy, amending section 63H of the IRO. It says out that if a taxpayer elects to apply the concessionary rate on the IP assets, then the amount of assessable profits for the year preceding the year of assessment would be subject to the concessionary tax rate. Now, concerning the provisional or holding tax rate, it will still be paid in accordance with the 16.5% tax rate. So that is in line with the previous amendments. Clauses 10 and 11, pages 35 to 39 of the markup copy. The two clauses propose amending the penalties, that is section 82A. Now, subsection 21 and 22 of the Schedule 17 impose additional notification and record keeping requirements on the taxpayers. So we have to set forth the penalties for contravention of these requirements. Now, clause 12, pages 40 to 46, that is the new Schedule 17 FD. Now, pages 40 to 45, that is the definition or the interpretation part of Schedule 17 FD. It defines certain terms. For example, eligible persons. It means a person who is entitled to derive eligible IP income from an eligible intellectual property. So it includes the owner and the licensee of the eligible intellectual property. Now, for eligible intellectual property, it includes an eligible patent, an eligible plant variety right, and a copyright subsisting in software. Concerning the other terms, it includes eligible IP income, eligible R&D expenditure. In Schedule 17 FD, there are other provisions to further define these definitions, so we will come to that later. Then we are at page 46 of the markup copy. Schedule 17 FD, subsection 2. As we have mentioned, the Patent Box tax concessionary measures on eligible IP income must strictly comply with the OECD rules. Subsection 2 ensures that be scheduled to be construed in a way that is most compatible with the OECD rule. Now, 47, subsection 3 of Schedule 17FD. Concessionary portion of assessable profits from eligible IP income subject to a concessionary tax rate at 5%. Still at 47, page 47, Mr. Rin Kong. Sorry, Chairman. Going back to page 44, sorry, you were going very fast. I understand that 50 AAC1 is like this. It says Hong Kong resident person. So why did you use this wording? Does it connote a particular meaning? So that is the definition for a Hong Kong resident person. That is 50 AAC. Now 50 AAC there are many provisions setting out the eligibility of a certain person to be qualified as a Hong Kong permanent person. So the main requirement is that it must be a person. Under the IRO, taxpayers must be a person. So if the entity is not a person, they will not be called by the net. So there are definitions including the person must be a natural person or a corporation or a partnership. So we put the focus on persons in the bill. And there are additional conditions for the person to be qualified as a Hong Kong resident. So that's why there is the word resident as well as the word person. Yes, please continue. Still, we are at page 47 of the markup copy, Schedule 17FD, subsection 4. It sets out that if an eligible person would like to apply the concessionary tax rate on the eligible IP income, then there must be a written election. And once the election is made, it is irrevocable. We're now at page 48 of the markup copy, subsection 5 of Schedule 17FD. If an election has been made by the eligible person on a patent, then the election is to be regarded as applicable to patents granted in pursuance of the original patent application and also the divisional patent applications, and the patents granted in pursuance of such divisional patent applications. In short, if the patent is granted, then the divisional patent will also be deemed as applicable for the concessionary rate. Pages 48 to 50, subsection 6 of the schedule. If an eligible person elect to apply the concessionary tax rates on a standard patents or patents variety right, plants variety right, and the registration for the OGP or the short-term patent is applied 24 months after the passage of this bill, then there must be an application or a grant of the short-term patents for the patents or plants variety rights in concern. And after granting of the patents, then the taxpayer must fulfill the substantive examination requirements. For non-local plant variety rights, there must be an application or grant for the non-local plant variety rights in Hong Kong locally. So after the 24-month transitional period, we will require the taxpayers to apply for an OGP for patents granted outside Hong Kong, and for plant variety rights, there must be a relevant registration in Hong Kong locally. Now, subsection 7 of the schedule, the meaning of eligible IP income, it includes income derived from an eligible intellectual property in respect of the exhibition or use of a right to exhibit or use of the property, or the imparting of or undertaking to impart knowledge directly or indirectly connected to the use of the property. It also includes income derived from the sale of the property, and also the sale of a product or service, which includes an amount that is attributable to the eligible intellectual property. It also includes amounts of insurance, damages, or compensation derived. Pages 51 to 52, subsection 8 of the schedule. An eligible patent is a patent that is granted inside or outside Hong Kong, and also the application. However, if the patent application is an application submitted 24 months after the implementation of this schedule, then it can't be an application for transferal of rights. So in other words, for application made 24 months after the regime has come into place, it must be an application for original patent grants or original grant patent. Page 52, subsection 9 of the schedule. The meaning of eligible plant variety rights includes a right that is granted or in existence in Hong Kong or outside Hong Kong, or an application of such rights. Page 53 of the markup copy, subsection 3 of the schedule. These are the formulas. To determine the concessionary portion of the assessable profits from an eligible IP income. So the formula is for calculating the concessionary portion of the assessable profits from eligible IP income. So it would be based on the assessable profits from the eligible IP income times an R&D fraction applicable to the assessable profits. Now, in a moment, there will be provision explaining what R&D fraction is. Pages 53 to 4, subsection 11 of the schedule, a formula to ascertain the assessable profits from eligible IP income. So it is based on the assessable profits from the eligible IP income, deducting the expenditure and also the concessionary amount. Subsection 12, ascertaining R&D fraction. As I said, the concessionary portion of assessable profits is calculated by profits times the fraction. So subsection 12 is about how we will come up with the R&D fraction. So it is actually imposed by the OECD. The design of the formula is the same as the OECD's formula. So the denominator is the eligible R&D expenditure with the total amounts of eligible R&D expenditure and other expenditure as the numerator. Now, concerning acquisition and also licensing fees are paid to, or development fees are paid to third parties or contractors, they will not be counted towards R&D expenditure. So there is a 30% adjustment room for the R&D expenditure. So you see that in the numerator of the formula, the amount can be will be multiplied by 130%. That's also in accordance with the OECD's rule. So as long as it doesn't exceed 100%, is fine. Now, subsection 13, eligible R&D expenditure and its meaning.
法
It's about the expenditure as a result of R&D activities, and is connected to the eligible IP to which the eligible IP income relates. On behalf of the eligible person by a person that is not associated with the eligible person, or in Hong Kong on behalf of the eligible person by an associated person of the eligible person that is a Hong Kong resident person. And the following expenditures are not to be regarded as eligible R&D expenditures, that is, interest payments, payments for any land or building, or for any alteration, addition, or extension to any building. Any expenditure incurred by the eligible person for obtaining the subject IP or any right in respect of the property from another person. Next, Section 14, meaning of NE, non-eligible expenditure. That is it is a non-eligible expenditure incurred in respect of the eligible intellectual property to which the eligible IP income relates. It's similar to brackets 13. From sections 15 to 21, meaning of abandonment, cancellation, declination, lapse, and conditional revocation and withdrawal. A reference to the abandonment, refusal, and conditional revocation or withdrawal of a patent or patent application is to be construed within 4 months. The patent applicant needs to inform the Commissioner of Inland Revenue and pay the difference. The taxpayer cannot enjoy the tax concessions in relation to the eligible IP. Excuse me, I'd like to go back to page 55. Section 13, brackets 2b. Do the payments for any land or building include the rents as well? The administration, does that include rents? Section 13.2b. Mainly is about buying land or building, the expenditure incurred therefrom. Does that include rents? I'd like to know rents. Does R&D expenditure cover rents as well? For rents, as far as we understand, well, it's not written in the legislation, but with reference to the OECD guidelines, rents are covered. They could be R&D expenditure, eligible R&D expenditure. So what about interest payment? Why are interest payments not included? This is an OECD requirement. As far as we understand, While the OECD is formulating the requirements or guidelines, it sets out very clearly what expenditure is included and what is not included. That is set out very clearly. While they are formulating these guidelines, they draw reference from different jurisdictions to see which expenditure is considered eligible under the different tax preferential regimes. The OECD drew reference from different jurisdictions. Of course, there were discussions, so it's not the case that it's the same across all jurisdictions. But in any event, when there are such guidelines, all jurisdictions, that is participants of the BEPS, also need to comply with these requirements. So for jurisdictions with IP tax concessions, for the purchase of land or building, it will not be considered eligible R&D expenditure. But what about interest payments? They are not eligible R&D expenditures either. So what about interest expenses? Can they be deducted with the tax rate of 16.5% or 8.25%? Yes, that's possible. Schedule 17FD Section 1. That's about the assessable profits. All relevant expenses need to be deducted. That's about ascertaining assessable profits from eligible IP income. In the assessment of the assessable profits, it cannot be included in the numerator, in the fraction. Page 68 to page 69 of the marked up copy. It's about the keeping of records to be kept. Someone needs to keep the record to make sure or to show that one does have the documents required and must keep the record for 7 years. '23 Transitional arrangement for eligible person with insufficient records. This section applies if an eligible IP income accrues to an eligible person during the period beginning on the 1st of April 2023, ending on the last day of the eligible person's basis period for the year of assessment beginning on the 1st of April 2025. The references to specified period in sections 13(1) and 14(1)(a) and (b) of this schedule are to be regarded as references to the period of 3 years ending on the last day of the eligible person's basis period. For the IP, one needs to keep the record, but before this mechanism is in place, the applicant may not have kept the relevant record. So under the guidelines of the OECD, we can provide a transitional period. Within the transitional period, one can use the eligible R&D expenditure and overall expenditure calculated on a 3-year average rolling basis, but upon the expiration of the period, the taxpayer, that is the applicant, will need to change from this value to using a cumulative ratio, that is to apply for the tax concessions. We are on the marked up copy of page 71. There are 5 more pages. I want to extend the meeting by an additional 15 minutes again in order to deal with the remaining business. Let's see if any members or the administration have any objection. If there's no objection, administration, please. (71 to 75) pages on the marked up copy. Schedule 17J, 19CB to 19CG are added. Then we come to the last one, the Schedule 45 of page 76. That's about the deduction of R&D expenditures. We add Schedules 17FC, 17FD, and 17J. Chairman, I have already finished a clause-by-clause scrutiny of the bill. Members, any more questions? If there is no more question, I'd like to ask members, do we need to hold a public hearing or invite submissions from the public in writing? This is the second step on the FSIE. Different sectors have already given us their views. So if members have no particular views, we will invite the public to submit submissions in writing to express their views. Members, please note, we will issue a notice to invite submissions from the public in writing. We have already finished the clause-by-clause scrutiny of the bill. There's no next meeting, so when will the administration resume finish the report with the House Committee before the second reading debate is resumed? In mid-June to late June, we'll resume the second reading and the third reading debate of the bill. Depending on the progress of the preparation of the bill by the Secretariat, as we understand, the earliest is the 12th of June or the 19th of June. It could fall on either the 12th, the 19th, or the 26th of June. The second reading debate will resume on either date. Well, I believe members would like to seek clarifications in relation to 40AZ. That is close to the heart of members. Members are looking forward to the list. That is to give members more information. Mr. Benson Look. Thank you, Chairman. Just now you said that you would invite the public to submit submissions in writing. So you should allow the industry sufficient time to express their views. You should also allow the administration and your good self, Chairman, to read the relevant documents. Well, you should allow your good self some more time. 2 weeks for the public to submit submissions. We can publish a notice as soon as possible. We can invite submissions in writing from the public on the LegCo's website. We can also, we need to wait for the administration to provide us with more information. So let's see if we need to convene another meeting. Legal advisor. The Chinese and the English texts of the bill are consistent. Any more reviews from members? No? Meeting adjourned. Thank you.